Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today, let's talk a little bit about the Department of Justice, the False Claims Act, and what President Lincoln might think. I'll have more in just a moment. Toward the end of the Civil War, the United States passed and President Lincoln signed something called the False Claims Act. If you're interested, you can find it at 29 USC section 3729 and the sections that follow that. The law came about as a result of what I would call shoddy work, and in fact, actually was shoddy work. In case you're wondering, the word shod, from which shoddy is derived, refers to the processing of wool, the fuzzy parts that come off, the things that you might see, for example, on the floor if you have a wool blanket. We used to call them woolly boogers in the Army. The shod is not really something that can be spun into yarn, and neither can it be used to make clothing. But because there was such a demand for blue uniforms for the Union, a lot of the people who made uniforms used the shod instead of the actual wool. And when the soldiers would get out in the rain, and of course, although you're not supposed to wash wool, you can wear wool in the rain without too much damage. Well, when they would get out in the rain with this shoddy wool, the clothes would basically disintegrate. And as you might imagine, that is not a good thing for a soldier out there trying to fight a war. So, to make a long story short, President Lincoln and the Congress got together and passed the False Claims Act. It was designed to go after people who sold goods to the government, and those goods were either substandard or the other situation. At the time, the United States Army quartermaster, who was the person in charge of supplying the Army, the quartermaster could go out to somebody who supplied horses, for example, and hand them a request for 10 horses. And then that person would send that request that they filled in along with the number of horses given to the government and get paid. Well, it didn't take a whole lot of theorizing to realize that a lot of those people were taking 10 horses, adding a zero at the end, and being paid for 100. And of course, any war is a terrible drain on an economy, and it was on the economy in the 1860s. So the government decided to go after a novel solution. The False Claims Act imposes treble damages, treble meaning triple. Basically, what happens is if somebody sells something that clearly does not meet the requirements of the government, then what happens is they get sued under this False Claims Act, and they have to pay, instead of the $100 that they got, they have to pay $300, or if it's $1,000, they have to pay $3,000. Then, on top of that, there is a civil penalty that it goes per claim. The civil penalty now is between $5,500 and $11,000. So, looking, for example, at healthcare, if a doctor or a hospital were to overbill for 100 procedures by only $1, they would owe $300 in damages, but they would owe a much greater amount in civil penalties. So that is how the law was designed to work. Then, over the course of the next 100 years or so, it got tinkered around a lot with, particularly during World War II. During World War II, there was a lot of what I would call profiteering among the defense industry. Now, everybody realized we had to beat the Axis powers, but there were a lot of people who thought there's no reason we shouldn't beat the Axis powers and they should get wealthy too. Unfortunately, a lot of that put our soldiers at risk, and people brought these claims under the False Claims Act. But in order to protect the defense industry, the Congress put in a provision that said, look, if the government has knowledge of the fraud, then you can't bring this lawsuit, because normally it wasn't the Department of Justice that brought the lawsuit. The way the thing was set up and incentivized was, if you knew that somebody was cheating the government, you could file a lawsuit on the government's behalf. The government would join that lawsuit, and you would stand to get between 15 and 25% of what the government got back. Now, I've talked a couple of times about cases involving the False Claims Act on here, but this is sort of the backstory for the False Claims Act. So in 1986, they went back and they removed the government knowledge defense, and basically what they put in was a public disclosure bar. And basically what the public disclosure bar says is, look, if this was revealed in the media, right, if you saw this on 60 Minutes and thought, wow, 60 Minutes says that this company, Acme, is charging the government too much money, you can't use that information you got off 60 Minutes to file a lawsuit. And of course, that makes a great deal of sense, because the court dockets would be jammed with people who claimed to be whistleblowers when in fact all they were doing was echoing what 60 Minutes had done. So what happened then was pretty much everything became a public disclosure. It was mentioned in passing in a government document from the state of Tennessee. Now suddenly somebody says, well, that put the federal government on notice. Not all of those claims worked, but many of them did. And one of the reasons that they did is because the Department of Justice is absolutely horrible about pursuing False Claims Act lawsuits. Here's the way the process works. I file a lawsuit against Acme Corporation for supplying bad brakes on Army vehicles. The government investigates. They have 60 days to investigate and decide whether or not to intervene, but they can ask for extensions as the statute provides. They never decide in 60 days whether or not to intervene. They always ask for an extension, at least 6 months, and usually they ask for additional extensions. In one case, it went 9 years with extensions. 9 years. That's a really long investigation. So what happens then? After they do their investigation, they have to make a determination whether to intervene on behalf of the United States government in that lawsuit. If they intervene, then they take over, process the lawsuit through to completion, and then pay the relator anything that is due. The relator is the person who brings the lawsuit. They pay them anything that's due. Again, unfortunately, the Department of Justice has an annoying tendency to take claims worth $300 million and settle them for $10 million. Now, a lot of times they say, well, that's because the defendant doesn't have an ability to pay. And of course, when you take the money and run, you often don't have the ability to pay. The government does a horrible job of going after these people, and frankly, it is one of the biggest scandals, in my view, in the Department of Justice. So today I want to tell you about two cases. The first of those is United States ex rel. Kraxberger versus Kansas City Power and Light. During the course of the case, we referred to them as Kansas City Plunder and Loot. So we took all of the information we had, including documents and everything, to the government, and the government said, nah, not interested. Well, there is a savings clause that says, look, if you believe in this lawsuit and you think you can do it, you take the case forward. And if you win, then instead of getting 15 to 25%, you get 20 to 25%. So we took the case forward. We did a lot of discovery. I had a good fellow attorney with me who worked really hard on this case. And we got to the end of the case where we were getting ready to get this to try to a jury. The defense came in with a bogus thing about public disclosure. They said that because the rate was disclosed in this particular case in a filing with the Public Service Commission, that it was a public disclosure. I'm doing a bad job here. Let me back up a minute and tell you what the key allegation was. At the time, the federal building in Kansas City was powered by steam. That steam came through a series of pipes under the Missouri River and up to the federal building where it was used to heat the building. Kansas City Power and Light came in and said, hey, look, we'll put you in a couple of boilers. You can make your own steam, and we'll give you a really good rate to make sure that you can do that cheaply. Except that when the time came to give them the rate, the Public Service Commission said, you can't give them that rate. We won't let you give them that rate. In point of fact, we believed and we alleged that they knew all along they weren't going to be able to get the rate and that it was basically a scam to sell 2 boilers. Now, the jury never got to hear any of that because the jury never got to hear the case. It was dismissed on a second motion to dismiss for public disclosure. The judge erroneously granted it. We took it up to the Eighth Circuit, and in one of the worst opinions ever written by the Eighth Circuit, and again, I'm speaking from a position of bias here, so judge that as you might want to. The government decided, or the appeals court decided, that the case was properly dismissed. It was not properly dismissed. We did not have the amount of money that it would take to take it to the Supreme Court, so that's where the case died. That is what is unfortunate, because at the time there was a provision in the federal law that said, if the government objects to a dismissal on the grounds of public disclosure, it can file its objection and the case won't be dismissed. We had everything. We took it to the government and said, look, this is a good case. And the government refused to give us that statement saying they objected. And so the case was dismissed. If you have any inclination to write to your senators or legislators in the Congress, I would urge you to do so and urge them to amend the False Claims Act to require something other than evidence of public disclosure. There is already a case out there from the Supreme Court that says if the government knows about the fraud and pays anyway, well, then it's okay. So why do we need this public disclosure bar? The fact of the matter is that in most cases, the public disclosure bar isn't really operative. It is not something that establishes that everybody in the community knows about a particular kind of fraud. And usually, the dismissals that are garnered on the basis of this disclosure bar are not really appropriate. At the end of the day, I don't believe that the court looked at the right things, and as a result, they dismissed this case, that it should never have been dismissed, but it would never have gotten to that point if the Department of Justice had done its job. Now, I am not being political here as much as it may seem that I am, because the Republican DOJ under George Bush and the Democrat DOJ under President Obama and the Republican DOJ under Donald Trump, all 3 of them screw up these cases. We often say in our line of work that the government does not want low-hanging fruit. They want boxed fruit. They don't want to have to do a whole lot of work. In fact, I had one Department of Justice attorney tell me, look, I've got the FBI bringing in cases where a doctor billed for 36 hours worth of care in 24 hours. What do I need you for? Well, you need me for the cases that the FBI doesn't know about. It is unfortunate sometimes that people make decisions, including Department of Justice attorneys, on the basis of their own unwillingness to do a little bit of extra work. And that is where I think the problem is. And again, it's not a political thing because this happens at a level below the political operatives. If we had good political operatives at the top of the Department of Justice who are insisting that these cases be evaluated quickly and fairly, and if they put the Department of Justice attorneys on notice that their evaluations were going to be reflective of bad decisions made in these cases, then I think you might see a little bit of a different result. So that's what I have for you today. If you have any questions about the False Claims Act, please leave them in the comments down below. You know, all the stuff we always ask you to do: like, share, subscribe, tell your friends, tell your neighbors' friends. And if you would, if you have the opportunity today and you have the opportunity to be kind to someone, please take that opportunity. It will make you feel great. Have a terrific day, folks, and we'll catch you out here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.